Brooke Wilfley runs a youth hockey association in Denver. By her own admission, when she started out, she wasn't even a big hockey fan. But once her 5 kids started playing, she figured she better get with the program. In early 2022, she started noticing some problems with CAHA, the Colorado Amateur Hockey Association, which governs youth hockey in the state. Money that was supposed to be flowing into the organization was instead going to the private company of its president, Randy Kenai. She started asking for details, first with Kenai himself and then with his board members. But since Kenai had been president for over a decade and had appointed most of the board himself, she got nowhere. But by this point, she was a tough-ass hockey mom, so she wasn't taking no for an answer. But eventually, she did get a letter. It wasn't from a regulator. It wasn't from CAHA's own board, who you would think would be grateful for bringing this irregularity to light. No, this letter was from CAHA's attorneys. They were launching an investigation into her. She had to pay tens of thousands of her own dollars fighting subpoenas. But, unfortunately for them, she also never gave up her own investigation. And she was about to be vindicated. Hey, welcome back to the Nonprofit CFO. On this channel, we pick a topic in nonprofit finance, take a look at a real-life story, and see what we can learn from it. So let's jump in. That youth hockey president, Randy Kenai, had a conflict of interest. As the president of this nonprofit, he had a fiduciary duty to get at the best deals that he could. However, as the owner of the businesses selling the products to the nonprofit, he had a competing duty to also get himself the best deals that he could. Fortunately, the IRS knows this and requires conflict of interest disclosures. For this reason, in October 2025, a judge ordered Kenai to repay $579,000, triple the amount that it found he had taken, plus court costs and attorney's fees. At trial, Kenai argued that he felt he was entitled to the money because of his efforts as the nonprofit's president. The judge told him that's not how it works, and Brooke Wilfley, who knew the rules all along, was finally vindicated. The CAHA story is a vivid example of what happens when conflicts go undisclosed and unmanaged. Often in the nonprofit world, people who care enough about a mission to serve on a board are people with business connections, family relationships that are often tied in some way to the nonprofit's mission. Conflicts of interest are inevitable and are not the problem. Undisclosed and unmanaged conflicts that can mask abuses of power are the problem. With CAHA, their board and leadership failed to identify the threat of this conflict. They ended up in a very expensive legal battle against first the whistleblower themselves, which is sadly not uncommon, and then against their now former president. The transactions that caused all of this mess came in early 2021, when USA Hockey asked CAHA to host a girls' tournament coming off the back of the pandemic. Kenai accepted on behalf of CAHA and chose his own company, International Sports Events Management LLC, to host the registrations. Now again, we're not debating whether his private company did a good job of hosting the registrations. The problem is that he was both the buyer and the seller. And he didn't tell his board about this. At least not all of them. We'll get to that. This went so well for everybody involved that they decided to do it again and again, eventually totaling over $1 million in registrations. Unfortunately, in addition to the disclosure issues, the subsequent audits and court cases found that Kenai had transferred $180,000 into his personal bank accounts, and that there was an additional $180,000 paid to fellow board member Jason Schofield for his work on the projects. None of this was disclosed to the other board members or to the IRS. Kenai and Schofield later said they believed their arrangement was known to the board. The judge, however, who presided over the 2-day civil trial, did not find evidence for that, and said that this arrangement did provide personal benefit to Kenai and Schofield, that she couldn't find evidence that was disclosed to the board or to USA Hockey, and that a general lack of transparency was a major factor here. If they had just followed the nonprofit governance rules, made the correct disclosures to their board and to their partners, there may very well have been legitimate and beneficial business happening here. I love legitimate and beneficial business. But for me, where they go from benefit of the doubt to bad guys, my opinion, is how they responded to concerned parent Brooke Wilfley. When she brought them her concerns, their response was not to investigate themselves, but to investigate her. A tried and true anti-whistleblower tactic used by bad guys since the dawn of whistles. They asked for her texts and emails from the last 2 years trying to prove a defamation case about her, that she was spreading unfounded lies about Kenai and his allies. Unfortunately for them, before becoming a hockey mom, Brooke Wilfley was a law student and knew how to fight back. But damage was already done. According to the USA Today, even after the verdict, many in the Colorado hockey community still believed Kenai. He had been in power for 10 years. He had made a lot of friends. He had potentially even treated a lot of people very well. But the legal system found that he had screwed up. He had made money off of this organization that he was supposed to be safeguarding and had ignored the safeguards that are in place to prevent this kind of conflict. And it didn't help that then he went after the accuser when she called him out on his bad actions. Charity Watch CEO Lori Siren has said that nonprofits need to avoid not only conflicts of interest, but also the appearance of them, because public trust, once it is damaged, is very hard to rebuild. That's very clear in this Kaha story. The legal system was clear about Kenai's actions, but the community was split. So what is a conflict of interest precisely? Well, the key here is the individual making the decisions. When an individual has personal interests that could be in conflict with decisions that are made on behalf of the organization, you have a conflict. And the key here is could. There doesn't need to be harm in order for a conflict to exist. The potential conflict exists as soon as an individual holds both positions of power. And when that happens, that's when we make those disclosures to bring other people in who don't have that conflict to make sure that what we're doing is always in the best interests of our organization. In a nonprofit context, this typically involves financial relationships, a board member voting on a contract with their own company, a family member being hired without an open process, a contract being awarded to a board member's business partner. But there are also some non-financial examples, like a board member serving on the board of a competing organization. The Kaha situation was a conflict of interest the moment that Kenai became a Kaha decision maker while owning businesses in youth hockey. Again, this doesn't have to be a problem, but it does need to be disclosed to make sure that the nonprofit is always protected against personal interests. BoardSource's most recent national nonprofit survey found that 96% of nonprofits have a written conflict of interest policy. If yours doesn't, it should. It's a question on the 990. That's something that a lot of board members may not know. Whether or not your organization has a conflict of interest policy is public knowledge. The IRS Form 990 asks if you have a policy in place and the degree to which that policy is enforced. It's public record, the 990. Major donors read them, funders read them, journalists read them, and an organization that says no to the question as to whether they have a policy or that can't describe how the policy is implemented signals to everybody that you may not be a responsible partner. To keep your organization protected, key staff members and every board member signs a conflict of interest form annually. I recommend doing it early in the year when you solicit your annual board gifts. Make it part of your annual routine. People's professional and personal circumstances change. Annual disclosure helps capture those changes. The disclosure form asks them to identify any relationships, business, family, financial, that could create a conflict with any decisions the organization might make. This includes business ownership or otherwise having substantial decision-making power with a related business, family connections to vendors or grantees, and service on other nonprofit boards. When a board member identifies that they have a conflict, the process is really straightforward. They recuse themselves from the conversation, they leave the room, they're not a part of the conversation or decision-making process at all. The board then documents in their board minutes that the board member with the conflict has recused themselves and were not part of the decision-making. And when that's put into the minutes, it's super important because later on, if anybody ever questions that decision or that conflict, you can bring up those board minutes and give it to them. Hey, finally something to do with those filed board minutes. What happened at Kaha was the opposite of what you're supposed to do. No disclosure, no recusal, no board vote approving the arrangement, no board minutes even saying that the board talked about these things. And unfortunately for the board president, a $579,000 verdict is what he bought himself. Strengthening your conflict of interest policies is part of good board governance, and is something that my firm, Tucker Business Services, helps our clients with every day. From full-service bookkeeping and payroll, to payables processing, to executive, financial, and governance coaching, my firm can help, and at a price you can afford. Our link is in the description. The Colorado Amateur Hockey Association became embroiled in a very long and very public, messy legal battle, all because they failed to follow some basic governance procedures. A recusal, a disclosure, a board meeting, some minutes. This isn't hard. They just didn't follow it. They didn't do those things, and the time that they saved not doing those was later taken out on them in a Colorado courtroom. Next episode, we're talking about something that makes a lot of nonprofit leaders uncomfortable: executive director salary. What reasonable compensation actually means under the law. Yes, there is a definition. What the IRS wants to see in terms of documentation. And what a lot of board members get wrong when they go to set their executive director salary. I'm Evan. This is the Nonprofit CFO, and we'll see you in the next one.